Justice Amy Coney Barrett had planned to expose an attorney she believed was out of her depth. Within minutes, the plan imploded. The nation's highest court went from quiet routine to breathless disbelief as Pam Bondi, once dismissed as all politics, no scholarship, unveiled a constitutional masterclass that forced Barrett herself to rethink the limits of federal power. How did an underestimated advocate flip the script on a Supreme Court justice in real time? And why does that moment now steer debates from state legislatures to law school lecture halls? Let's rewind the tape. Amy Coney Barrett rose through academia, clerked for Justice Scalia, taught at Notre Dame, and built a reputation for textual precision. Her questions slice like scalpels, and attorneys usually feel every cut. Pam Bondi carved a different path. Florida's first female attorney general, a tough prosecutor known for media savvy and political grit. Critics labeled her charisma over case law, praising her instincts but doubting her depth. When Bondi took the helm for Federation of States versus Department of Commerce, court watchers smirked. She's no constitutional theorist. They were about to eat those words. The lawsuit targeted sweeping federal regulations that, according to 17 states, bulldozed traditional state prerogatives in taxation and land use. If Washington won, the ruling would cement broad federal reach for decades. If the states prevailed, a new barrier to national authority would emerge. Quietly, scholars whispered, this could be the most important federalism case since Prince. No pressure. Oral argument began like clockwork. Formal greetings, measured tones. Then Barrett leaned in, voice resonant, eyes locked on Bondi. Your theory contradicts at least 3 precedents, counsel. Perhaps you should revisit Harrington versus Davis before presenting it here. Gasps. A justice had essentially told Bondi she hadn't done her homework. Cameras clicked. Commentators drafted tweets before Bondi even breathed. Bondi's reply came calm and unhurried. With respect, Justice, Harrington actually fortifies our claim. She quoted Chief Justice Reynolds' limiting language, invoked Justice Kavanaugh's concurrence, and revealed how the 3-part test favored state sovereignty under today's facts. Her delivery felt less like defense and more like lecture, the kind that makes even seasoned professors scribble notes. Pivoting, Bondi cited Westmoreland v. United States, a 10th Circuit blip most lawyers barely recall. Justice Sotomayor pounced, "Counsel, that isn't Supreme Court precedent." Bondi nodded. "Correct, Your Honor. Yet this court adopted Westmoreland's reasoning in footnote 23 of Montgomery v. Louisiana, a point directly relevant to our tailoring requirement." Eyes widened. Footnote 23. She had come armed to the teeth. Moments earlier, justices lounged. Now they leaned forward. Clerks paged frantically. Barrett's brows knit. Not in doubt, but dawning respect. Questions arrived rapid fire from Thomas, Kagan, Alito. Bondi fielded each with composure, weaving doctrine, history, and policy into seamless strands. Barrett tried a new flank. "Accepting your view shrinks our decade-old Denison framework. Explain why we shouldn't fear unintended fallout." Bondi didn't parry. She dissected. She read Gorsuch's own language, recognizing Denison's limits, and argued today's regulations exploited precisely the loophole Denison warned against. Barrett listened. Pen paused mid-note. Then Barrett unleashed the hypothetical, a twisted knot of conflicting state-federal mandates so diabolical that law students would sweat over it for years. The room tensed, sensing a trap door under Bondi's feet. Bondi smiled. That scenario crystallizes the tension we face today. She outlined 3 core principles: sovereign primacy, proportional tailoring, anti-commandeering, citing Nick, Murphy, and Barrett's own Wisconsin manufacturing opinion. She mapped each principle onto the hypo, turning the puzzle into a clear-cut win for the states. Silence, then murmurs. Even Barrett's expression softened into what observers later called thoughtful awe. The Chief Justice warned, "Counsel, your time has expired." Before Bondi could request leeway, Barrett did it for her. That single act, justice advocating for more time on behalf of the attorney she'd challenged, spoke louder than any headline. Meanwhile, the federal government's top lawyer scribbled frantic revisions. His opening remarks, crafted overnight, suddenly felt brittle. Reporters whispered that his team searched Westlaw in real time, desperate to counter Bondi's flood of citations. Within an hour, SCOTUS blog dropped a mid-argument post. Bondi's tour de force redraws federalism battle lines. A prominent liberal scholar tweeted, "Set ideology aside. Bondi just served a masterclass." #pulling a Bondi surfaced. Overnight it trended worldwide. Clerks later leaked snippets of conference chatter. Barrett openly conceded she had underestimated Bondi's scholarship. Justice Kagan reportedly said, "We were treated to a graduate seminar in federalism." Even Justice Thomas, usually laconic, called Bondi's framework elegant. 3 months later, the court delivered a 6-3 decision for the states. Gorsuch's majority opinion mirrored Bondi's tripartite test almost verbatim. Scholars dubbed it the Bondi test. In a concurrence, Barrett referenced her own prior rulings, acknowledging Bondi's persuasive synthesis of precedent. Some observers called that footnote the real revolution, a justice publicly crediting an advocate for shaping doctrine. Within weeks, district courts applied the Bondi test to strike down federal rules on agriculture subsidies, historic preservation permits, even broadband fees. State attorneys general cited Bondi like scripture. Meanwhile, Congress quietly commissioned studies on the regulatory rollback the decision might trigger. Law firms that once scoffed now bid 7-figure retainers. Harvard, Yale, and Stanford invited her to teach intensive seminars on constitutional strategy. Students packed auditoriums, hoping to learn how to pull a Bondi. Barrett, too, emerged enhanced. Commentators praised her for intellectual humility, proof that rigorous minds evolve when confronted with better arguments. In a keynote weeks later, she said, "Legal brilliance can emerge from unexpected quarters. The bench must never confuse resume with capacity." 6 months after the ruling, Barrett and Bondi shared a Federalist Society stage. Their exchange was cordial, probing, almost collaborative. Asked about their initial clash, Barrett quipped, "It reminded me why oral argument remains vital. Sometimes the court learns as much as it teaches." Bondi answered, "Advocacy isn't combat. It's joint pursuit of constitutional clarity." Late-night hosts cracked jokes. Law review editors penned tributes, and corporate trainers borrowed the phrase for presentations on underdog breakthroughs. In classrooms, professors now open modules by asking, "Who can tell me the 3 prongs of the Bondi test?" Hands fly up. Legal observers in Canada, Australia, and the EU began citing the decision while debating their own federal-provincial tensions. A German professor wrote, "The United States has exported many doctrines. The Bondi test may be the most intriguing in a generation." At its core, the Barrett-Bondi saga teaches 3 universal truths. Preparation beats perception. Credentials impress. Mastery dominates. Humility magnifies authority. A justice willing to rethink earns more respect, not less. Dialogue drives evolution. When adversaries engage honestly, entire systems advance. One routine hearing, one dismissive remark, and one extraordinary response reshaped American federalism. Pam Bondi rewrote the narrative of her career, and Justice Barrett affirmed that the court's strength lies in minds agile enough to pivot. Together, they turned a showdown into a milestone. If you found this breakdown as riveting as we did, tap that like button, hit subscribe, and ring the bell so you never miss our next deep dive into the courtroom dramas rewriting history. And tell us below, which side of the Bondi test will your state land on first? Stay curious, stay critical. See you in the next episode.